started here. I know we're waiting on a couple people, but I don't want to hold everyone up. Couple things I want to mention coming up with the FSSA. Our executive retreat is coming up this October, tentatively set for October 11th. Keep your eyes out for more details. We should have them within the next couple weeks, and it should be a great event. Couple other things. We have a few more webinars coming up. Tuesday, May 21st at 1 p.m. Save the date for a webinar on reputation management presented by Storage Group. Also in June, Tuesday, June 11th at 2 p.m., a webinar on revenue management. Also in August, we're going to have a healthcare changes webinar. We don't have an exact date, but with the laws changing and going into effect next year, we're going to have a webinar on how that's going to affect you and your business. Also in September, we're going to have a lien law webinar. Hopefully we'll have some new legislation to teach. Regardless, we'll go through the existing lien laws as well. And then in November, we'll have another webinar on accounts receivable, tips, techniques, and processes. One last thing, we had a tremendous turnout for our 2013 Expo. Tons of great feedback. Thank you all for coming out and having fun and joining us to learn and making it a good time. If you didn't get a chance, we already have our dates confirmed for next year. March 17th to the 21st of 2014 is our next Expo. We will be at the Embassy Suites, Lake Buena Vista, again, just because all the feedback we heard was just overwhelmingly positive about the location, about the speakers. We couldn't be more happy with the success. So hope to see you again next year there. And if you didn't make it this year, hope to see you for the first time there next year. But without further ado, I'd like to introduce, we have a great speaker for everyone, and I'm glad everyone could join us. I know this can affect a lot of businesses tremendously, but I'd like to introduce our guest speaker, Henry, or he goes by Hank Didier Jr., is the founding partner of Economic Recovery Group, LLC. Hank graduated summa cum laude from Florida State University with dual degrees in management and multinational business, and with honors from Duke University School of Law. While at Duke, he focused his studies on environmental law and business litigation. Didier began his legal career working on environmental land use issues and how businesses can appropriately develop land while also respecting the sanctity of Florida's natural resources. He then moved on to do business litigation at two different statewide law firms where he represented large corporations including General Motors, Allstate, Walmart, and in various legal matters. He then shifted his focus to consumer justice, handling complex litigation matters, and now works tirelessly to protect the rights of Floridians and others throughout the Southeast. In the wake of the Deepwater Horizon disaster, Mr. Didier has chosen to draw up both upon his experiences as a business and a consumer advocate to help businesses and individuals negotiate the BP settlement. As a partner in Economic Recovery Group, he is working to address the direct and indirect economic impacts of the spill throughout the coastal cities of Florida as the state, its businesses, and its professionals continue to recover. So we know we have an expert here, and without further ado, I'd like to welcome Hank. Hank, you have the floor.
Well, thank you very much. And I hope that today I can at least provide a good foundation of understanding for what's been going on with the new class action settlement. It's obviously called the Deepwater Horizon court-supervised settlement program for a reason. It is a settlement program. It's not going to involve traditional litigation anymore. And really what the goal of Economic Recovery Group is, and the goal I have today, is getting information out to the people who need it so that businesses and professionals can make educated decisions about how they want to proceed with regards to looking at whether or not they qualify under the program and what they'd be entitled to. And obviously with this group and what you all do, you certainly are included within the terms of the class action settlement. And on a business-by-business basis, there may be many of you who actually have claims and have rights under the program to be compensated if you had any kind of financial loss that in most cases was indirectly caused by the oil spill because the economy as a whole dropped down. So I've put together a PowerPoint for those who'd like to also read along when they listen to these. And so with that, let's get started so we can get through this. And if there's any questions, and it's set up today, I'll try to answer any questions anyone has. As a practical matter, just as a very short introduction, ERG, or Economic Recovery Group, we're a statewide law firm. We are representing businesses from Key West all the way up through Pensacola and the Horn of Florida, and we do work in the other affected states, Mississippi, Alabama, northern Texas. But we are a Florida law firm, and our focus, our offices are here all along the west coast of Florida because that's what we focus on, helping businesses here in this state. We have 35 full-time lawyers, CPAs, and financial professionals helping our clients move through the process. And what we have learned is that that dedication, that specialization in doing nothing but this really has benefits to our clients and gives us the ability to really get to know every aspect and nuance of the program so that we can help people through it. And hopefully by speaking to you, I'll be able to relay in a very concise manner some of the highlights so you can understand it also. I think a good way to start is just historically. I mean, why do we have this and what is the program? The program, like I said, it's a class action settlement. It was negotiated with BP inside of a federal court in Louisiana, resulting in this, what we call the settlement program, to pay out what is estimated to be about $8.5 billion in claims. Under the settlement program, so you understand, while that's the estimate, BP has agreed to pay all valid claims if they're timely made. So if that number, that estimate's wrong, and it's actually $10 billion in claims get filed, all of those will get paid under the program, but they do have to be filed. There's estimated to be about 800,000 potential claims out there. The likelihood, just seeing the data, is that a fraction of those will ever actually make claims because you have to act for your own benefit under this class action. It's not something that if you sit back, you're going to get a check. You have to take affirmative action, you have to get evaluated, and you need to file a claim through the program that meets all of their guidelines to get paid. And the current deadline to do that is April 22nd of 2014. So we are very, very close right now to being 1 year away from the ultimate deadline to file a claim. If a company does not file a claim by then, and assuming the date does not get continued, then the companies and all the professionals and consumers in the state will forever be barred from making a claim for losses to their businesses. So this is a short window of time, relatively speaking, and it just requires action by the people who take the time to look at it and get evaluated. Now, I get the question asked all the time, well, does my business qualify? Should I look at this if I'm in construction, if I'm a lawyer, if I'm an accountant, if I have a hair cutting business? It doesn't really matter. The reality of the program is that it has a very big breadth. And there are a few limited categories which I'll walk you through, but at the end of the day, the program was designed because BP and everyone who looked at the effects of the oil spill on the coast recognized that, hey, the indirect economic impacts of this disaster caused a constriction in consumer spending. It caused a greater drop in the already existing drop in home sales, home building, the sale of real estate, the drop in our economy that was going on in this period of time. And so it really exasperated a lot of different things. And the program has been developed to look at that change to the coastal counties as compared to the rest of the nation. And there is definitely a difference. And so the program was developed to say, okay, if you're a business in a coastal county along the Gulf Coast of Florida, then you are a potential claimant. And what we need to do is we need to look at your business records, and if that in fact shows a trend, a loss or a drop in your income or a decline in your growth, whatever it may be, then you're going to qualify and you're going to get compensated for that. And that applies really, if you think about it, it's every coastal county, and it's all the way out to their eastern boundary line. So, for example, all of Tallahassee is included. This goes all the way out to the east side of Tampa, almost to Plant City, where the Hillsborough County line is. So you can understand how big this area is, and since it covers almost every business, that's why they believe there's 800,000 potential valid claims that exist out there. Now, when we talk about your industry, self-storage, and the commercial property industry generally, there's no question from what we are seeing that your industry was affected. It is in a lot of ways similar to many other businesses, just because you had a drop in tourism and you had fear. And fear, we all know, in an economy causes the constriction of consumer spending, and when that happens, it affects every business of every type. That was exacerbated in our communities along the coast because you also had actual job losses when the tourists didn't come, and that made it worse for everyone. And then as that is occurring and people are losing their jobs and they're in fear of losing their jobs, they're not spending money, and things that may be a luxury, they stop spending on. And that would include, or they stop paying. You know, and that has happened. Self-storage, for example, you could suffer if your clients stop paying their bills. And we see all variations on that. What is interesting about the program is you couldn't really look at every single business and decide exactly why the drop occurred. And so these economic formulas are looking at a much broader economic principle, which is if we look at how a company earned money historically and we compare it to the year to spill and we compare it to the year after the spill, and the spill happened in 2010, we will see a trend of a drop in 2010 in their revenue and a rebound. Now, that's not even annual revenue. They're looking at nearly 3 months in succession where you can show that kind of trend compared to the years before and the year after. If that trend exists, there's no explanation needed for your business of why that trend exists. It is presumed that it's oil-related and indirectly related to the drop in the economy that the spill caused to us versus, say, a different state away from the coast. And that is essentially how the program works. Now, if we look at the realities of what's going on under that very broad and very generalized objective measure that's been created, we see a little over 150,000 total claims have been submitted to the program to date. Of those total claims, you have to understand there's other claims than just business economic loss claims. So a business economic loss claim is what it sounds like. It's a business that suffered in some way because of this downturn under the terms of the settlement program. So of that 41,472 claims as of making of this PowerPoint had been filed with the claims program by businesses. Of those, one of the things we're seeing, and a cautionary note, is that 43% of those claims, of that 41,000 claims, were rejected by the program because they were incomplete. And that is a staggering number and is a very real problem because those 43% of the people would receive an incomplete notice. And they have different forms of the why they get the notice. But essentially it's saying, listen, the program has very specific requirements to file properly. If you do not meet every box and check off every box and provide everything you need, it is incomplete by definition. If it gets kicked out because it's incomplete by definition, you have 30 days to cure it. If you don't get that information back inside of 30 days, you will be forever barred from payment, even if you have a valid claim. So, and the vast majority of people who get kicked out for being incomplete are not making it back in time. And so we are telling people on a cautionary note, you do need legal representation, in my opinion. You do need to make sure it's done right the first time, and you need to be aware of the very strict and very very dramatic consequence of filing something that's not done right the first time and not getting it fixed in 30 days, because that is being strictly construed and strictly enforced, and a lot of people are never going to be paid on their claims now because of how they were filed, and that is obviously a problem. There have been almost $9 billion in payments made to date. And if you look at all of the business economic loss claims and what their current claim value is when you average it, it's $233,000 approximately. So you can obviously see with that average, this is something that makes sense for every business to look at. We're not talking about a few dollars here. This is a significant amount of money for an organized business who, because of their revenues, can justify recoveries in this range. And so it's something that we encourage all businesses that want to be evaluated. You should do it, because the reality is this is going to be effectively an economic stimulus to the west coast of Florida that is really going to help the entire economy rebound, and it's being infused into the economy through the businesses themselves, which is a very creative idea, and I think a very effective idea. Now, if we back up and we talk maybe in a little more detail about the program, you've probably heard about there's different zones, and depending on what zone you are in, and this is the location of your business, where you report your business on your tax returns, there are 4, in fact. There is Zone B, really doesn't apply here in Florida. It's only Louisiana. So you have 3 zones that matter, and we're going to flip to a map really quick. But Zone A think of it the barrier islands, Sanibel, Captiva, Clearwater Beach, St. Pete Beach, the last bridge out, and all of the Florida Keys. Zone C businesses are really the ones that are closer to the ocean on the west coast, and as you move inland, there are defined boundary lines, largely tracking large roadways, that then shift it to Zone D that go all the way out to the eastern county boundaries. It is harder to qualify in Zone D than in Zone C because you're farther from the coast, so the standards are a little more strict with regards to what you need to show to get compensated. But if you qualify, whether you're in Zone C or in Zone D, you do get paid the same. The economic formulas for what you're entitled to once you qualify are exactly the same. So this is, if you haven't seen it before, the zone map created by the program to let businesses know whether or not they are even possibly covered by the settlement program. You can see the dark gray section and that line, the straight lines that look like boxes working your way from the bottom of the screen up. Those are, if you overlay it with a Florida map of our counties, those are eastern county boundaries. As you go in, you can see what I was talking about. You see all of the red, and that is Zone C is the red, Zone D is the dark gray, and then yellow you can see the islands off of Clearwater, Pinellas Park, up there near Cape Coral, and of course the Florida Keys you see in the bottom are all Zone A claims. Zone A is very different from Zone C and D, and the only reason I say that is if you are in Zone A, effectively what is an island, BP has always recognized that the businesses located on those barrier islands or the Keys were dramatically impacted because of their strong tie to tourism. So there is no proof necessary of a loss. If you have a business in Zone A, you have a claim and you are entitled to be compensated. There are also a number of multipliers because of the nature of those economies out there and the nature of the businesses out there. that will multiply the loss. So if it's a $50,000 loss, you may have a 3-time multiplier. You'd be entitled to 150 grand. The businesses in the red and the dark gray is where most of our work is. We largely work for non-tourism based, and of course we do tourism also, but the focus of ERG has always been representing businesses of all types that are not necessarily tourism get through this process. And that would include your industry. And the key to determining whether or not you have a claim, very simply, is if your business is located on this map in one of those areas, you need to get evaluated. The only way you can know if you qualify and what you're entitled to is to do the work and get evaluated and look through 2 different things we need to do it. The first step is going to be obtaining 5 years of profit and loss statements for your business on a monthly basis. And that 5-year period is 07 through 11. So the first month is January of 07. The last month is December of 2011. That is 5 years or 60 months. And then the tax returns for the same 5 years, 07 through 11. And what you're really looking at is 07, 08, and 09. Those records create what's called the benchmark period, i.e., what did you make in the way of money, how did you make money, and what were your existing kind of normal patterns. You then take those 3 years and you compare them to 2010 to see whether or not there was a change in your patterns. If there was a drop in what your business did historically the first 3 years to what happened to your business in 2010, that drop matched with a rebound or an increase in 2011 the following year creates what's called a V pattern under the formulas. And if that V pattern is shown in your financial records, you qualify. And then you will get paid what you're entitled to under the economic formulas. Now, a lot of people say, hey, I didn't lose any money in 2010. When you look at my annual tax returns, I made more money in 2010 than I did in 09. A lot of people say that. But that is not a way that you can really determine whether or not you qualify or not, because the program is not doing an annualized review. They are looking at 3-month periods of time. So, for example, you could pick May, June, July of 2010. You compare it then to 3 different options. May, June, July of 09 to see if you have the drop you need, the average of 9 and 8 for those 3 months, or the average of 9, 8, and 7 for those 3 months. 07 was a tremendous year for a lot of businesses. So when you average 7, 8, and 9 together, a lot of times you will see the drop when you compare that average to 2010. Now you could also pick October, November, December, or August, September, October, or any variation of 3 months from May to December. So you really have to, A, look at all the variations, and there's 54 variations you can run, and you need to be looking for the variations that create the drop in 2010 when you're comparing apples to apples with regards to the 3-month period, and then a rebound in the same 3-month period of 2011. If you're in the red zone, knowing that basic setup, you're looking for an 8.5% drop under the formulas and a 5% rebound. If you go farther into zone D, you're looking for a 15% drop and a 10% rebound. Now again, this is very formula driven, so those numbers, while just to give you a feel for the kind of drop and rebound they're looking for in the changes from the benchmark years to 2010 and then 2011, the reality is these are very specific economic formulas that are built to cull through your profit and loss statements to determine how you figure out if it's an 8.5% drop or not, or a 5% rebound, for example, if you're in C. So it's not something you can eyeball. It's very definitionally driven by the program mandates. And the only way to do it, very honestly, is you've got to run it through the formulas. That is how it works. That's the big picture. Now, we've already talked about these different things in general, but just to give you a feel for why you have to do the work. Each zone, whether it's A, C, or D, has different rules that apply. So you got to make sure you identify where your business is and you're applying it to the right zone. They then have that general financial test we just talked about of looking through 60 months of financials for that January '07 through December of 2011 period to figure out if you have that pattern, that trend of patterns. In doing that, there's 54 different tests. Assuming the business meets the causation test, meaning they qualify, you then run, there's 63 different variations you run to try to determine first what their base compensation is or what you're entitled to under the program, and then there are 18 additional variations you want to run, which we call the step 2 compensation calculations, which add to and then maximize the claim. That is obviously 135 variations if you're punching those numbers in. And it is the running of all of those variations for every client that gives you the ability on a client-by-client basis to maximize the claim and maximize, in the first place, the likelihood of qualifying or getting causation. That's why I say you need legal counsel, you need people who know what they're doing, and you need people who can run all these variations and understand that how you put in data, how it's interpreted does matter. It's the whole garbage in, garbage out idea. You need to make sure that you're putting good data in out of the financials for the company so that you're getting good data out. Why now? That's another question I get. Why should I file a claim now? I am sure that a lot of people have read about the appeals and the lawsuits that BP has been filing lately directed at the settlement program administrator. Now, a lot of that, now that 2 weeks ago the court has ruled upon it, has largely become a moot point. The settlement program continues to run. It continues to be administered in the way that the settlement document says it's supposed to be, and the court has now affirmed that, in fact, the administrator is doing it correctly. That is what's going on. But just so you know, there's a lot of news going on. Don't let it deter you from looking at a claim. A lot of that has, at the end of the day, had no impact on the functioning of the program, and the program will continue on. There is, right now, as we said, about 150,000 claims been filed with 800,000 potential or anticipated claims. There is a benefit to getting in and not being caught in the wave of activity that we anticipate as you get towards the end of this year into the next year, as people who have procrastinated decide they want to do it. And that is going to cause, we see foreseeably, a lot of backlog in the program. So if you are considering doing it, this is a good time to do it. There is, as always, appellate procedures that are going on. They will continue to go on for the next year or two. Again, you're going to hear about those, but don't be confused. They are not affecting the function of the program. And one thing that's important to know, let's say a year from now, or before the program wraps up on April 22nd, 2014, some appeal changes some element of how the program is administered or works. If you have filed a claim and if you have been paid, the program document says very specifically that money is yours, and even if the program changed and it would have applied to you, there is no what we call grab back. They can never come back and ask for their money back. If you get paid under the terms of the agreement at the time you file, you're paid, you signed a release, that's a binding document, and the money is yours. So again, while I don't think anything's going to change, if it did, again, that's another reason that go in now and you won't have to deal with any uncertainty that may happen if anything changes over the next year. And of course, there's a lot of room right now. They've built a lot of capacity for the program, anticipating these claims, and right now they are, in our view, dealing with them every day, very efficiently dealing with them. So this is, again, a good time to get in before we see the backlog occurring later this year. With all that said, I would say be proactive is the best advice I can give to you. If you are located in the zones of that map, get evaluated. How we work, how a lot of law firms work, is that we will look at you as a client. We will do an evaluation of your claim to see if a valid claim exists. if no claim exists, you never pay us anything. You don't pay us for our time. You don't pay us for the cost or the evaluation or anything that's required to figure out if you qualify and what you're entitled to. That's just how we are set up. We absorb all that cost because we want to be a conduit for people to figure out whether they're entitled to compensation. If you have a claim, then the way the program's set up is that the federal court said that the way that lawyers will get paid for clients they serve is a 25% contingency fee off of the monies that are paid after they're paid. So you never pay anything up front. If you had a $100,000 claim, for example, the fee would be $25,000. Now, the other thing the program did, recognizing that, and recognizing that you really want the money to go to the business hurt, is if you had a $100,000 claim, the program also set out certain multipliers, or what they call risk transfer premiums. If you're a business in any one of these zones, you're going to have at a minimum a multiplier of 0.25, which means we wouldn't file your economic loss claim of $100,000 if that's what you lost. It would get filed as $125,000. You can see the impact of that is largely to offset the vast majority of the fees that would be charged. Now, the other thing the program did was they recognized that there was going to be CPA and accounting services needed to do this financial analysis. So the program has a reimbursement program also. We at our law firm have hired all the CPAs and financial analysis into the law firm so that we can guarantee confidentiality of the entire process to our clients. But what that also allows us to do is we bill what would normally be paid by the client for accounting services, we bill it to the program so our clients don't pay it. That reduces the cost to our clients. So between multipliers for fees and other factors and the cost reimbursement program that you can utilize from the program mandates itself, the vast majority of whatever your loss is under the formulas goes back to the client or whoever pursues the claim. That is how ERG works. That's how we are set up. And that is how we are serving all of our clients to get through this program. So with that, I try not to get too deep into all of the details because it can be overwhelming at times. That is a very big, broad, but accurate description of the program, and I hope that that helps you. My partner likes to talk about the program as, you know, he remembers getting the recent TV class action notice in his mailbox saying, fill out all this paperwork and you're going to get this small amount of dollars out of this class action. He, of course, like many people, never did anything about it. It wasn't worth his time. The fact of the matter is the average business claim now is $233,000. I think most people would agree that if you're in the zone and you may have a claim, the realities of the nature of the claims, the size of the claims, and the amount of work that's actually required, because once you provide us the financial documents, my law firm is supposed to do the work. That's what we're here to do, and that's what we specialize in doing. So I would encourage you, with that being said, do not let this stimulus program pass you by. If you have losses, they're going to show up in your financials, whether you know they're there or not, and if they're there, you're going to get paid. And that is how the program is intended to work, and that is what we do at ERG. You can always visit our website, erglawfirm.com, for more information, and we are always here as a resource to you all to answer any questions you may have as you look at this further or as you want to go forward. But I would encourage you, whether you're talking to my law firm or talking to someone else, you know, get evaluated if you have a business, because there's no downside to do it, and it's only going to serve to be an economic stimulus for the West Coast. So are there any questions, or can we take questions today? Tim or Robert?
Hi, Hank. This is Robert. Yes, we can take questions. If anyone has a question, you can raise your hand, or you can type in a question.
Hank, Hank, this is Tim. Are you able to see the questions?
Yeah, if someone types in into the chat, I saw Lindsay had sent me a message earlier. I saw that pop up.
Okay, you have a question from Delilah Scott, and I'll read the question off to you.
Okay.
Is Miami, Florida covered? She missed the map portion
Sure.
of the presentation, and she wanted to know if Miami was covered.
The answer to that question is Miami is not within a claim zone. It did not extend up the East Coast. Under the studies, it didn't show the same economic impacts as the Gulf, and so the entire East Coast of Florida was excluded from the settlement program.
It seems that Maria had a question. Zone C, 8.5% and 5%, and she has a question mark.
Yes, so in Zone C, if your business is in the red zone, or Zone C, you'll look for an 8.5% drop. Think about that as gross revenue drop, and again, it's on a 3-month basis for any 3 contiguous months between May and December, and then a 5% increase in 2011. That becomes the V pattern, and that means you qualify.
John has a question for you. He's asking where the map may be found or can be found.
Sure. This map can be found on our website. It can also be found if you go to Deepwater Horizon Settlements, plural. That is the actual settlement program's website, and you can find it there. But either one of those places, you can find the map. You can also email me directly if you like, and I can send you the map. My email is hank@erglawfirm.com, and I have it in my phone, and I can send you the map you're looking at right now very quickly.
That's all of the questions that we have right now, Hank. Robert?
Wonderful. Last chance, anyone with a question? Well, thank you very much.
Robert, we have one more question from, it looks like from Walt.
Okay.
Is Lakeland out of the zone?
Lakeland is just beyond the zone. It really stops at Plant City at the Hillsborough County line. So yes, it is outside of the zone.
Very good. That's the last of the questions.
Well, it's my pleasure to help, and we're always here and available to answer questions. And again, if something comes up, that is my email address. Feel free to ask.
Thank you so much, Hank, and thank you all for attending, and have a wonderful rest of the week.
Yes. All right, take care.
Take care.